Welcome to INSURALEX webinar on class action in Europe. My name is Marta Olczak-Klimek and I am a chair lady of INSURALEX Europe and partner in OKW law firm, an exclusive INSURALEX member from Poland. We invite you to join this live webinar with experts across the European Union who will present their national class action and elaborate on their thoughts of how the new directive might change the legal landscape. I would like to briefly present INSURALEX organization for our listeners today. INSURALEX is a group of more than 50 independent law firms from Europe, North America, Latin America, Africa, Asia, and Middle East. We specialize in insurance and reinsurance. INSURALEX firms work for a wide range of clients, including insurance and reinsurance companies, Lloyd's syndicates, insurance and reinsurance brokers. We specialize in multinational matters. INSURALEX is also ranked in global chambers as a leading law firm network. Let me present now our today's speakers. First is Alessandro Giorgetti from Studio Legale Giorgetti, INSURALEX exclusive member in Italy. The second one is Andreas Weinzierl from Tramposch und Partner, INSURALEX exclusive member in Austria and vice president of INSURALEX Global. Ian Pérez from Belzuz Abogados, INSURALEX exclusive member in Spain and Portugal. Stephen Carter from Carter Perry Bailey LLP, INSURALEX exclusive member in United Kingdom. And last but not least, Danielle Gardiner and Karl Weisheit from Lawyers Forensics International, who is INSURALEX sponsor. Thank you very much for your continuous support of INSURALEX. And I warmly welcome Ian from Belzuz Abogados, Spain and Portugal.
Yeah, so hi everybody, good afternoon. So in the next 20 minutes, I'm going to try just to break down a little bit what is the legal framework in Spain and Portugal for representative actions. And maybe the first thing I have to say is that we have no class action in Spain and Portugal, just the same that happens in Austria and quite differently what is happening in Italy right now. So, but it is true that we have different mechanisms for the protection of several interests that are affected by the same behavior. So we have two different scenarios in Spain and in Portugal. The first scenario is the accumulation of actions. That is the possibility of different actors filing different actions before different courts and with different proceedings, just to be accumulated before the same court and under the same proceeding. The key element here is a factual connection between the different cases. Under this scenario, the accumulation of actions, it is not restricted to consumers, but it is also just applicable for other traders or, for example, in cases of a cartel or unfair competition. So this key element, the factual connection between the different cases, has been treated by the Supreme Court in Spain, a quite controversial ruling that dates back to 2015. It is a case related to speculative financial products in which there were involved consumers, but also enterprises. So the legal defense of the bank stated through all the proceedings, so in the first instance, then in the appeal, and then before the Supreme Court, that there was no connection, there was no factual connection, there was no homogeneity between the different actions filed by the different consumers and the enterprises and accumulated in the same proceeding. However, the Supreme Court in Spain decided that there was a factual connection between the different cases, even damages. So this ruling of the Supreme Court in Spain just opened the door to a massive litigation in terms of financial products. But this is not the case until now. And then we have the second scenario in which we are focusing today. That is one action with different parties, the class action-like mechanisms in Portugal and in Spain. So we can make the difference of these class action-like mechanisms in three broad domains. So in the labor domain, we have injunctive actions. The main actor here are the trade unions. and just to prevent ongoing behaviors of certain employers just to infringe the, let's say, the rights of workers. Then we have the criminal jurisdiction, and we have that particular figure, legal figure of the popular accusation. And for example, we see this resort, this legal resort in, for example, environmental cases, environmental damages. And then finally, where we are focusing today, that are the actions related to the protection of consumers and users' rights and the unfair competition. So actions in the civil and commercial jurisdiction. So the object of these, the second scenario in the civil and commercial jurisdiction, the object are the protection of collective interests, but also diffuse interests. What is the difference between these two kinds of interests? So collective interest is the scenarios in which we can exactly determine the number of people affected by any specific behavior. And then diffuse interest is something that we cannot concretize the number of people affected by a specific behavior. And just we also have to make the difference between the different nature of the actions regarding the protection of consumers in Spain and in Portugal. So there are two different natures of the actions. So injunctive actions, just trying to prevent certain behaviors, ongoing behaviors, and then compensatory actions, aiming to obtain economic compensation. So in terms of compensatory actions, we have to have in the back of our minds the executive limitations. The executive limitations of representative actions for the protection of consumers' rights in Spain and Portugal depends on the specific piece of legislation that we are applying to the case. And here we have strong differences between Portugal and Spain. So for example, according to the Portuguese legislation, for the contractual responsibility, we have the executive limitations is of 20 years, while in Spain is only 5 years. And for non-contractual responsibility, we have just 1 year in Spain, while in Portugal we have 3 years. So when we are talking about representative actions for the protection of consumers' rights, we have to take into account the executive limitations when we are seeking an economic redress. So what is the current legal framework that we have in these two countries of Southern Europe? So first of all, we have in Portugal, we have a constitutional protection, or what has been called the popular action, the ação popular, that could be quite related to what Alessandro was saying at the very beginning of today's webinar about that specific institution of Roman law. So according to the Portuguese Constitution of 1985, the ação popular is recognized for individuals, so every citizen, but also for qualified entities. And this is another kind of entity. This is one of the main differences with regards to the Spanish legal regime. So in Portugal, you have that constitutional protection of the ação popular, and these kind of actions are related to the protection of public health, consumers' rights, quality of life, and the preservation of the environment and cultural heritage, as well as the defense of public property. Whereas in Spain, we have in our constitution of 1978, there is a constitutional mandate for the provision specific mechanism for the protection of consumers' rights is provided in Article 51. The Constitution of Spain dates back to 1978. However, we had to wait 30 years until the Spanish legislative power decided to provide a specific mechanism for the protection of consumers' rights. As you can see, here in Spain, we have some lazy legislative power. However, related to case law, the Supreme Court of Spain acknowledged that legal standing of qualified entities in 1997 in a quite important case, at least in a historical case for the tort law in Spain, the Colza case, related to a massive food poisoning. It affected more than 20,000 people in Spain. And finally, in the end, it was granted a compensation for more than 3,000 million euros. In that historical ruling of 1997, the Supreme Court of Spain acknowledged the qualified entities, the legal standing just to claim not only just to file injunctive actions, but also compensatory, represent all the consumers that take part of that specific organization. So what happens then? So we have a certain constitutional protection for the consumers' rights. So what happens then? So the representative actions in Spain and Portugal just follow the same patterns of any other civil procedure in Spain and in Portugal. So you have to go to the ordinary jurisdiction. The only difference is that in Portugal, they have a specific preliminary violation. So when we file an assault popular, so a popular action, the public prosecutor as well, so along with the judge, has to ascertain which is the viability of this assault popular. So they can also make a specific research, and if there are no chances of viability, of preliminary viability, it is rejected a limit. So you can see here that the popular action in Portugal is quite restrictive, very restrictive, in fact. So so as I said before, there are no differences between Spain and Portugal in this specific sense. So with regards to legal standing, it is acknowledged to the public prosecution, consumers associations, groups of consumers. And the key issue here is the definition of consumer. As Andrea said before, it is quite unclear. At least it leaves some space for judicial interpretation. So what is to be a consumer? What means the status of consumer? And then we have in Spain and Portugal, we have an opt-in system for this class action-like mechanism, legal mechanism. So depending on the type of interest that is at stake in this moment, we have two different paths. So if we are talking about a collective interest, so if we can determine the people that are potentially injured by specific behavior, the qualified entity has to prove that try to notify every injured people by that specific behavior. So, for example, in this case, just say in the case law, for example, again in Spain, the Appeal Court of Madrid, in a quite recent ruling, 2018, in a case related to more than 4 million consumers, 4 million, this is fine. So it was related to a package of telecommunications. It was against one of the most important telecommunications corporation in Spain. So rejected a collective action for the protection of that 4 million consumers because there was no notification of that 4 million consumers. So the qualified entity said that it was quite difficult just to notify that 4 million people. But the Appeal Court of Madrid said that there are mechanisms provided by the Spanish law to notify that 4 million people. And it does not matter the number of people affected. What does matter is if you can determine the number of people potentially affected. So as you can see, it is quite tricky, the mechanism. And also, when we diffuse interests, there is, of course, no prerequisite of notification because it is not possible to concretize the number of people affected. Only it is a task of the court just to give public warning of an ongoing proceeding for the protection of consumers' rights. So then there is no opt-out system, at least in Spain, but there is an opt-out system in Portugal. So the ruling in that case can be not binding for the consumer that decided to opt out of the action. However, and even though there is still the judicial precedent in both our jurisdictions, so it is not binding, but it has some impact in the interpretation of similar cases. So in both jurisdictions, we don't have punitive damages, which is quite important, and it's a main difference with regards to the United States. We have no punitive damages, and it is possible, at least it is feasible, third-party funding for the protection of consumers' rights. And just to give you some hints about how these representative actions functions and differs in Portugal and in Spain, we had a quite recent ruling of the Appeal Court of Madrid related to the Dieselgate, the so-called Dieselgate. I'm pretty sure that you know perfectly know what I'm referring to. So it is the massive fraud committed by Volkswagen with a specific software related to environment. And we have, as you can see, for example, in Spain, January 2021, the Appeal Court of Madrid mentioned and referred to the Directive 2020, the European Union, even if it has not been transposed to our legal framework, and even if it had not entered into force in that moment. So instead, the Appeal Court of Madrid, with relation to more than 7,000 people affected, that there was certain homogeneity between the harm produced in each one of the consumers. So granted more than 22 million euros in terms of compensation. This is 3 months ago. Whereas in Portugal, the same case, the same facts, the Dieselgate, in 2017, the court of the Tribunal de Relação of Lisbon dismissed the popular action because there was no homogeneity between the different cases of particulars. So as you can see, the legal I just came to the end of my exposition, but just to give some ideas with regards to the potential directive in both our jurisdictions. So I completely agree with Andreas and with Alessandro. I think that at least in the case of Spain and Portugal, the impact is going to be quite limited because we already have that specific legal mechanisms for the protection of consumers in Portugal and in Spain. So, and then on a second stage, it is also true that the directives makes reference to the protection of the legal tradition of each one of the members. It's likely that Portugal and Spain are going to protect their existing legal mechanisms, except in one thing, and I completely agree with Alessandro, the cross-border litigation. This has to be amended, and it has some impact, at least in Spain and Portugal. I also think that we are going to witness some litigation with regards to the data protection, and also with e-commerce, so the digitalization in Spain and Portugal. But and with regards to the insurance industry, I personally think that there will be no mass litigation, at least not in Spain and Portugal, because of the structure of the insurance market in our jurisdiction. So we work with subsidiaries of holding companies, and it is not likely to happen. It has not happened until now, fortunately, and we think that it is not going to happen even if this directive makes some changes in the medium future. So thank you very much. I would be very pleased to answer to any question you have at the end. Thank you.
Thank you very much to all speakers: Alessandro Giorgetti from Italy, Ian Pérez from Spain, Portugal, Andreas Weinzierl from Austria, Stephen Carter from United Kingdom, and of course our colleagues. Thank you very much for Lawyers Forensics International, Karl and Danielle. Thank you very much for sharing your American experience with us. I assume that we can finish now. I don't see any questions, so thank you very much for your attention, and I hope to meet you again on our next webinar. Thank you and goodbye.